law review has a special place in my heart. My very first article published ever was at Santa Clara. I was still a law student, and my law review, the George Mason Law Review, decided not to publish my note. I thought it was pretty good. It was about Google Street View and privacy. This was in 2007. It was a brand new thing, and they passed on my note. So I submitted around on Espresso, like all of you know all too well. And I was shocked when I got an offer from the Santa Clara Law Review. I was like, wow, that's pretty cool. So you published it, you made it the lead article in the issue, so I'm always very grateful for the opportunity. I'm also grateful to be here on this panel because it's about federalism. For the last 8 years or so, I've been the only person on panels saying that we need federalism, that we need to put limits on federal power. So I'm actually grateful that at one point we have an area of agreement in one area perhaps, but maybe we have more in the future. As Seth alluded to, I will be talking in my time about Section 1373. I'd like to talk about the two principles previously mentioned, the spending clause doctrine and the commandeering principle. My first part about the spending clause will be somewhat tentative. And the reason why is we don't know exactly what the executive branch seeks to withhold from the states. The complaint that Seth filed an amicus in favor of was largely speculative. Like, we're worried that we're going to lose this, and that's a legitimate concern. But we don't really know what's going to happen. So as actually Seth was speaking, Charlie Savage of the New York Times updated an article on his post saying, how much money is at issue? So we have breaking news right here in Santa Clara. So I'll give you a hint. What's at issue are what's called justice grants. The state of California, the entire state with 128 cities and counties, will lose $10 million. $10 million for the entire state of California. That's peanuts. Peanuts. You're not mounting a spending clause challenge for $10 million. If they go beyond that, maybe we can talk, but this is peanuts. New York City, $4 million. New York's budget is about $100 billion for the year, billion with a B. And here's the kicker. All these grants said you are getting this money on the condition that you stipulate that you're complying with Section 1373. There's an explicit condition in that. So unless we know more, I don't think the spending clause challenge will go very far. But then again, maybe this judge in San Francisco will join the resistance and issue a nationwide injunction stopping the president from even considering withholding money because resistance, right? But we'll put that aside for a moment. But I am not optimistic. Now, if they go past it and they try and withhold all federal funds for the detainers, that's an issue because the number of courts have held as a Fourth Amendment issue with refusing to comply with the detainers. So there you actually have, I think, a little more to stand on. But I don't think that's going to be the basis. If they're smart about this, we'll start small, let San Francisco sue, and they'll probably lose this one. But who knows? The second issue, which I do want to focus on much more, involves the commandeering line of cases. And there's a couple cases to discuss that are relevant. The first is called New York versus United States. The second is called Prince against the United States. And there's a third, I don't know if I mentioned it, I missed it, Reno v. Condon. Okay. So what is commandeering? It's the general principle that the federal government can tell states and state officials to enforce federal law. So in New York, the United States, the court held an opinion by Justice O'Connor that the federal government could not require New York State to take title of low-level radioactive waste. That may sound very awful, but it's like the stuff in a little watch that makes it glow in the dark. It's actually not that awful, but it's bad stuff, right? That would require the state to pass laws and implementing various federal policies. This was a key precedent in the so-called Reagan Revolution of federalism. Fast forward about 10 years until 1996, sorry, 97. The case came up, Prince of the United States. This involved the Brady handgun law. You may not know this in California, but people buy guns with their background checks. Generally, it's a very quick process. It's a federal database. It works in rapid succession. And that database did not exist in the 1990s. So the statute said, until we get this database up and running, we'll have local sheriffs and chief law enforcement officers run background checks on officials. People who want to buy guns. A number of sheriffs brought suit. Sheriff Jay Prince of Raleigh County, Montana, and Sheriff Mack in Arizona, and they argue that this amounted to a commandeering of state officials.
This was a bitterly divided 5-4 case. Justice Stevens said there is no commandeering power in the Constitution, period. He wrote that of course Congress can force state officials to enforce federal law. Joining in were Justices Ginsburg, Breyer, and Souter. That Haiti doesn't age well, I suppose. In fact, Justice Stevens wrote a book a couple of years ago, five amendments or six actions. He actually proposed to amend the Constitution to overrule Prince. They wanted to amend the Constitution. So Jeff Sessions reports your sheriffs are enforced immigration law. Unfortunately, no one listens to him about not to. It's just a book. He turned 97 the other day. Justice Stevens. Amazing. He's so right. It's pretty impressive. But going back, the majority of this by Justice Scalia found that this provision of Brady had been acted was unconstitutional. And most people don't actually know why. Your common class probably learned in the 10th Amendment case. That's not true. It was a necessary and proper clause case. At the very end of the opinion, we turn to necessary and proper. And here follow me. This is important. Necessary and proper. It's not a single item. There are two phrases: necessary and proper. And what Justice Scalia said was the Maryland landmark case only discussed necessary. Right? Necessary means useful, convenient. Is it useful to the government? We'll have these children from background checks. Yeah, we'll concede that, right? But is it proper? Is this intrusion of state authority proper exercise of power? Here, the court said, no, it's not. The court action up on this line, we bomb the case for a couple minutes. The key part here was not proper to state sovereignty and the officials of the individual sheriff's local. This is primarily what we're relying on the Secretary of State. It's not really an amendment on state lack of the Constitution because it's not proper. Okay. So Prince was actually decided as the sixth law was being developed. 96 law came on here before. Then came the New York which my colleague graciously explains the detail. But the Second Circuit an opinion and found that Prince was not controlling on Section 373. Why it didn't force the states to do anything. Right, it wasn't saying wired fed by the nation. It says we can't interfere with your willing and voluntary local officials. There's a big difference. Prince specifically did not discuss the laws that require you to share information. Now there's another statute that talks about. It's a law that children. It's a 1990 law. The law says that all states must report missing children to the National Center for the National Center for Children in a certain number of hours. This is not a conditional thing. They're required to report any kids are missing. Right? I think people agree this is a good idea. Right? It's go missing. It's traveled. Whatever you want to know what they are. But this is the same premise under which the sanctuary descends. Right? You want information in your jurisdiction. Aliens not recognizing missing. So there's actually a strong parallel there. But the Prince said we're not going to laws require information, and in the second session, this does not require information. Indeed, what they said is frustrating law. This provides a surprise room for the second New York City, massively round the board. Yes. They were trying to create federal law and resist federal law with this policy, social justice, right? New York petition, the Supreme Court denied it. The Solicitor General filed a brief in opposition, saying that this is Prince. Right, this is not an reporting requirement. Okay, so I don't against you reading into Prince. It's not one's force. California or Sacramento, wherever you are, to do anything. That they aren't. The relevant case in Reno convict, which involved the federal driver's protection. So this law listed a lot of states sold your DMV or DMV money. It was a good rap. Congress said you can't sell information. That's not proper, right? South Carolina saying we want to. The Supreme Court rejected South Carolina's challenge, saying that a state as the owner of information selling it is Congress can regulate the way they're doing it. Critically, they're not commandeering the state. They're not forced to do anything. But if they do it, they need to follow certain rules. Okay. So again, Reno v. Condon didn't exactly resolve this issue either. It wasn't about whether they had to disclose information, but they were disclosing it how. The key question, and this is why I think this entire case will turn on, is an aspect in the Second Circuit decision that was not well reasoned. It wasn't. They punted on the issue very poorly. The issue is this. Does New York City have the power to direct its workforce to operate in a certain fashion? Right? There is an aspect of sovereignty that the mayor of a city or a sheriff or whatever you want to say can tell his workers how to do their jobs. They're not the feds coming in. Okay? This law is telling California you can't direct your local officials how to act. You have to tell them to act in a certain way. Judge Winter, who was a Second Circuit judge, very smart judge, said these concerns are not insubstantial. Right? If you're a law student, your judge writes not insubstantial, that means substantial. Right? These concerns are not insubstantial. Right? It is undeniable that Section 1373 interferes with the city's control over their employers. Friends, this is the question, right? This is the issue. The spending clause, I don't think they'll be smart enough to stay away from this. They don't even bank it in California. There are enough members of Congress, the Republicans who don't want to lose funding for the state. They're not going to bankrupt you, right? But the question is, are they suing? Oh, so all these suits by San Francisco will be proactive. What they flip it. One case, Arizona versus United States. Remember that one? Remember Arizona at SB 1070 to show your papers law? Remember that one? Eric Holder filed suit saying, you are obstructing federal law, and I'm going to try to stop your law, to enjoin your law. That's how this is going to go down if I was them, right? I'm going to sue San Francisco or New York and say, you are obstructing federal law. You're obstructing federal law. You're interfering with it. We can't enforce our jobs. And that brings up point free center, the Constitutionality of 1373. And at that point, we can discuss whether San Francisco or California, whatever your jurisdiction is, has a strong enough sovereignty interest in managing their workforce to avoid those sorts of claims. And I'll admit, I am divided on this question. I spent a lot of time this week in anticipation of our panel thinking about it. And I'm on the fence. I think the sort of information being provided has been required in many other statutes. I mentioned the missing children one. There's also another law that says DMVs must report information to EPA about car quality. I mean, there are a lot of mandatory reporting requirements. And what I want to get across to you is this. In the event that the court actually strikes down Section 1373, the people in this room may celebrate, however briefly, because there are many aspects of law. Thank you. There are many aspects of law that are now in jeopardy. Laws involving environmental law, right? If California doesn't need to report information about immigration, then Texas doesn't need to report information about the environment. Whoa, right? If New York doesn't need to report information about immigration, then Oklahoma doesn't need to report labor violations. Whoa. So my fair weather federalists in the room, be careful what you wish for. A rejiggering of precedent could be a boon for federalism, especially if you have buy-in from liberal justices. Nothing would make me happier than a 9-0 opinion by Justice Sotomayor about the clear statement rule. Nothing would make me happier than that, right? A 9-0 opinion from Justice Ginsburg or Kagan that why we need to have stronger federalism protections. My God, I'll take that to the bank. Because when another couple of justices retire, those precedents are very useful. So be careful what you wish for. I will be happy to get a decision striking out 1373. I think it's a stupid law. I have no problem with sanctuary cities as a matter of policy. I don't think they're very effective. I'm sorry, I don't like 1373. I think sanctuary cities are fine. I don't have any problem with them. But if this case goes this way, then, viva la federalism. Thank you very much.